Hey, David, my community association wants to amend the leasing restrictions in our community. Can they do that?
Hi, my name is Dave Muller from Becker and Polikoff. The question we'll be addressing today is leasing restrictions. Can you do that? In other words, can you adopt leasing restrictions in a community association where leasing restrictions didn't previously exist, or can you amend your leasing restrictions? First thing we have to go over is there is a distinction on this issue between condos and homeowners associations. Let me first start by talking about condominium associations. The good news on this issue is we have very clear authority from the Florida Supreme Court on this issue. In 2002, the Florida Supreme Court addressed a situation involving a condominium association where they previously allowed annual rentals, and the condominium association declaration was amended so that annual rentals weren't permitted, only seasonal short-term rentals were permitted. Several condominium owners were upset about that and challenged the restriction, and it went all the way to the Supreme Court. The disgruntled owner's position was that when they bought in, the declaration had specific restrictions that allowed annual rentals. And they said because that's the way the restrictions were when they bought in, those restrictions could not be changed later. Ultimately, the Florida Supreme Court sided with the association and not the disgruntled owners. The Florida Supreme Court said that the association did have the authority via an amendment to the declaration to adopt amended leasing restrictions. They said that all owners were on notice of the fact that a declaration can change because of the amendatory clause that was contained within the declaration. So that case stands for the proposition that a condominium association can amend its leasing restrictions. Now, there is a caveat here, as there often is in the law. That case was decided in 2002. In 2004, the Florida legislature adopted an amendment to the Condominium Act. And let me read what it says. It's found in 718.110 subparagraph 13. And it says, an amendment prohibiting unit owners from renting their units or altering the duration of the rental term or specifying or limiting the number of times unit owners are entitled to rent their units during a specified period applies only to unit owners who consent to that amendment and unit owners who acquire title to their unit after the amendment. What does that mean in layman's terms? That means that in a condominium association, even if you get the required percentage to amend your declaration to provide for new or different leasing restrictions, it only applies to those unit owners who voted in favor of the amendment or those who take title after the effective date of the amendment being recorded in the county in which the condominium is situated. For homeowners associations, the analysis is similar, although there is no statute in the Homeowners Association Act similar to the one found in the Condominium Association, or similar to the one found in the Condominium Act. Bottom line, you should consult with your association attorney before considering any amendment that impacts leasing restrictions. So, can you do that? The question being, can you amend leasing restrictions in your community? And the answer, of course, is yes, you can, but there's a caveat, and you should definitely consult with your attorney. Thank you.